welcome back, everyone, from the lunch. At least those of us here. Welcome back, also everyone who is joining us online. So first of all, we have a small announcement. Originally, there was supposed to be the speech of Miguel Angel Paniagua from the Spanish Parliament. Unfortunately, due to some emergency meetings, he cannot be with us right now. Maybe he will join later, then he will speak after the panel. But with that in mind, we will start the panel discussion slightly early. So it is my great pleasure to introduce Jella Benner Heinacher, the now Vice President of Better Finance, but also long-time President.
This is a bit too tall for me. So, I'm not a minister and I'm not an MEP, so hopefully you're not disappointed. But we will just start our panel that we planned a bit later. And I do have the pleasure to be the moderator of this high-level panel on advancing collective redress for European shareholders. So, let me briefly introduce my panelists, and I will ask them to come forward and take their seat. Let me start with Mark Northway, the chairman of the World Federation of Investors. Please, Mark, come here. Then let us welcome Flip Schreurs. Hopefully I pronounced it well. He is the chairman of the Fiat Chrysler, today Stellantis, Investors Recovery Stichting, briefly called FCIRS. Welcome, Flip. I think it's great that you came here. Then we will have Rafael Tripero representing our host. He is an AEMEC advisor and also managing director at Cremades and Calvo-Sotelo. So first of all, let us say thank you to the host for using this wonderful facility for our conference. We like it because it's so transparent. It reflects a little bit what we expect from the companies. And we will also have a further guest of surprise, I would say, from Italy. He's called Iacopo Destri, and he will join us later online. And he will also have a presentation on the situation in Italy. And finally, I hoped that our US colleague would also be here. You've seen him this morning, David, but unfortunately, I think he will join us a little bit later. So before I open the panel, I would like to say a few things on the situation that we have in Europe. Can you understand me with the micro? A little closer. Is that better? Yeah. Great. Now, currently, we do have a directive, a European directive called Collective Redress Directive, CRD. And to be honest, this directive has a lot of deficits from our point of view. It aims to establish a harmonized system across the EU member states to bring representative actions on behalf of consumers. Supposedly, this directive was supposed to take place and get into force in June 23. But to be honest, most of the EU member states, exactly 24, did not transpose this directive. And we will discuss why this is the case and what the disadvantages of this directive is. And let me pick out just a few key points out of this directive that could be criticized. And let me start with the scope of this directive. So currently, the directive makes sure that it covers EU consumer protection laws, but it is excluding key financial instruments It is also excluding direct shareholdings unless member states choose to expand this scope. So we will hear from Italy the example. They transposed the directive, and we will see how they transposed it in their country. Also, and that's the second point I would like to cover, we should talk about the standing. Currently, only qualified entities, typically consumer organizations, can initiate collective actions. For cross-border cases, stricter criteria apply to prevent abuse and ensure independence. Well, I'm very happy to hear, and there I look to Ola and Mattis and these colleagues, we as Better Finance decided to apply as qualified entity so that in the future we will be able to take part in these collective redress procedures. A third point I would like to mention is the question opt-in or opt-out. Unfortunately, the directive allows both systems, which we do not like as much as Better Finance. We believe, especially for cross-border cases, that we will need the opt-out system, which is in our view much more efficient. And opt-out, maybe just to explain it a little bit, means that the investor is automatically part of the proceedings unless he or she is opting out. So our experience is, and that will be interesting to hear about the Dutch system, our experience is that the opt-out system is much better because you get many more investors involved, and it's much more efficient than the opt-in system. Okay, so today we would like to discuss in detail how could we improve the position of the shareholder in Europe to give him or her an equal access to collective redress mechanisms. And if I look at the existing directive, we as Better Finance have a clear position on it. We say, please expand the scope of the CRD and please do not exclude direct shareholders and bondholders, which means that the most important people are excluded from these kind of claims. Secondly, we would like to have, as I indicated, the opt-out system all over the EU. So there is still some room for improvement with regard to the directive. And finally, we also look at the system, who is allowed to take part in these claims. And we do think that we should also have ad hoc foundations that very often represent shareholders, as we know from the Netherlands, that they should also qualify for these legal actions, and it should not be limited to qualified entities. But I think these are all the questions that we will discuss in detail now, and a very important part also, its costs. As always, we all know the rule, the loser pays the costs, and that's something that in our experience is deterring. I mean, litigation costs are deterring individual shareholders from participating in these procedures. So what do we have to do to encourage and improve the system? We need to regulate third-party litigation funding and maybe even think about the after the event insurance, following models that we see in the Netherlands. And of course, we should not forget litigation funding is the key enabler of shareholder actions as we know it from the US. Finally, and I think it's a very important idea from Better Finance that we should push forward, we should establish an EU-level redress platform, a register this kind of a central EU investor protection hub, preferably at ASAP. That will come in July 27. And this would be the public register for all of the investors to find out what is going on and to have the information how they can join these actions. I think this would be the cornerstone of to increase the confidence of the investors to take part into these actions. Okay, that was my brief introduction, but I think we should take the opportunity and hear a lot about the experiences of my colleagues in the Netherlands, Italy, UK, and Spain, and hopefully later also the US. So let me start. I actually should sit down because as a moderator, standing is not as good. So does that work? Really? Okay. So let us take a closer look at the Dutch system. First of all, you know that Flip is still, the Dutch system is still for us kind of the best practice that we have in Europe. We already participated in quite a lot of Stichting cases in the Netherlands a long time ago. And I think it would be a great opportunity that you present us a little bit the Dutch system and showing it and explaining it by the case of Fiat Chrysler, Stellantis. What stands behind this case and why is it so interesting for shareholders and investors? Flip, please.
Thank you, and thank you for the invitation, especially from Better Finance, who is a big friend of us in this case. Stellantis Fiat Chrysler, as you will know, is involved in the emission fraud. In, I think, 2012 or 13, became known that Volkswagen had an emission fraud system in its cars, in its diesel cars. And also other car builders were looking into if they also frauded. And Fiat Chrysler then denied very strictly, very firmly, that it also has frauded the emission systems. That later turned out not to be true. And within the periods between 2014 and 2017, we think that shareholders have been misled by currently Stellantis. And well, there are already some collective claims in the benefit of the car owners. And in the United States, there has already been several cases regarding the interest of the investors. And Stellantis has not denied, but has cooperated, has confirmed that it has committed fraud, and has settled the cases both with the state and with the investors. $300 million have been paid in the United States. And so it is a bit surprising that exactly the same, investing in exactly the same company, have not been, have not received any indemnity. That was surprising to us, and therefore we have started the case. And in fact, we're really in the middle of it. Next Monday we have a court. We have filed a claim last August, and we received, well, maybe I can tell now a little bit on the system, because there are two phases in such a claim. And first we have the requirements. Is our foundation, our Stichting, does it meet the requirements to enter into the case? And Fiat has written a memo of 140 pages detailing all the details that I think that we did not meet. And that's what the case Monday is about. Okay, what the system is that we had a system until 5 years ago that worked quite well. WCAM, we call it, WCAM. And in those days, there were various settlements between companies, large corporations, and collective claim entities. But 5 years ago, in the Netherlands, it was thought that that was not enough, and that there should be a system that would stimulate more out-of-court settlements. And on the other hand, the defendants have lobbied to have a system that gives finality, more finality. Both problems were dealt with. So we have a very delicate system in which necessary that you have an independent entity, completely independent entities. I have nothing to do with, well, I drove a Chrysler once, but I have nothing to do with Fiat Chrysler. I have nothing to do with the law firm, not with the funder. We have a board of 3 independent people. I'm a corporate litigator, knowledge on legal points. We have someone familiar with financial and another. And we have also an independent supervisory board with evaluator, with a professor, and with an accountant. And that entity, that Stichting, that is the party who is the claimant. We furthermore have to have some book building. That's very strange. To answer your question about opting in and opting out, the system in the Netherlands is opt out, at least for the Dutch. So it's not necessary if you are a Dutch investor who has damage from that fraud. You don't have to opt in, you can opt out. That means that all the Dutch investors are interested, are in. Nevertheless, we have to show some standing. So we have to find those investors, and that explicitly holds for the foreign investors because there is an opt-in system. And that's a very, because why is it opt-in? Because the defendants, the lobby of the defendants 5 years ago, that it would be too risky if the goal of the entity was idealistic or vague. So there would not be enough finality. And therefore, for foreigners, it's opt-in. But, and that's going to be decisive in this case, you can ask for opting out also if the case is clear and if the group investors is clear. And we think that that is the case in this Stellantis case, because we are only dealing for the interest of investors on the Milan Stock Exchange between 2014 and 2017. We don't know the group, but it's a very strict group. So we think that it should be opt-out for all investors.
Well, Flip, thank you very much for this introduction. I think there are a lot of questions with respect also to the international investors that you also mentioned. You do have an agreement with Better Finance to also represent international investors. And I know we discussed it in Germany several times because the main question was, did you have to buy the shares via Milano Stock Exchange or not? And how can I see it from my invoice? So let me turn it the other way around. What is the expiry date for this claim? Because that's the first question the investors interested ask. Maybe you can say a bit more about this. And also you can say maybe a little bit more details on where you have to buy. You shall have bought the shares of Fiat Chrysler, and maybe then we can get even further in the information.
Okay. Well, we filed a claim before the expiry date, so that is safe. And the investors, it is very nice that a lot of them already have taken contact with us, mainly thanks to Better Finance, because that really helped. Reached out to Better Finance, and they contact their local members, national members. In the meantime, we have already, within the last 6 months, 4,000 individual investors, including 50 pension funds, so professional parties, and also quite an amount of money and possible damages. So that expiry date is not a problem, and the next expiry date is, of course, after we have success and we have an indemnification rewarded, then there starts a new period. So that's on the expiry date. I don't see any real problem.
Yeah. What about where you bought the shares, Milano or somewhere else?
The shares are only traded in the States and in the Milano Stock Exchange. So in the States, there is a settlement already. That is one of the defending points of Stellantis, of course. But we are only interested in people who have bought shares in Fiat, Chrysler or Stellantis. And if they paid in euros, well, that's more or less decisive. Because I don't think that you can trade.
So, which means that all individual investors of Fiat, Chrysler during this period of time that did not buy in the US, they qualify.
Yes.
So that's an important information, I think, for all of us.
From my point of view, they qualify, and possibly a lot of people don't know exactly the dates, or they bought before and sold after. Never mind, just take contact with us, and that comes later.
Yeah. Now you told us already a little bit about your two instruments. What is it called? WCAM and the WAMCA. Sounds difficult on first sight. What does this mean for international claims? Does it limit the claim altogether? I mean, before it was easy in the Netherlands to file a collective action. Now it seems to be much more difficult than before. And you also mentioned, and I think that's an important point, what is required by court, from for example, from the boards, from the Stichting. Maybe you can say
an entity. You were so kind to introduce me as the best practice in Europe, at least the Netherlands. But on the other hand, there is still a lot to improve. The goal that much more out-of-court settlements were reached after 5 years, it has not been reached at all. We have until now with the WAMCA not one settlement reached already. On the other hand, we don't have any Supreme Court cases. We have 100 cases pending. I think that there are some 40 and several appeal court decisions. So I guess that the defendants are still trying to find out which defenses will work and which not. But I hope until now everything goes well for the claimants. So that is, but it's really tough. I noted that Fiat had 140 pages with, I must say, blah, blah, blah. Just details. For instance, is the board dependent? Is the board qualified? Is 4,000 people, 4,000 individual investors enough, etc. That is the main point. That is too much. I think that there are too many demands on the procedural requirements. That's also for the international parties, of course.
So we all look at the court decision on the meeting on next Monday, and of course we would like to keep informed on what is coming out there. I think it is for us very important to see how it develops in the Netherlands, since it's the only country, more or less, where we can possibly, as international investors, also benefit. But let me turn maybe to Iacopo behind me. Iacopo, I'm sorry, I turned to the back to you.
No worries.
Okay, can you see me?
Yes.
Okay. So thank you very much for joining the panel, and warm welcome for you that you join us, and you brought a presentation with you and that we
Yes.
would like to have a look in, so you can tell us a little bit, what is the situation of collective redress in Italy? I know Italy is one of the few countries that transposed the directive. So we are curious to find out how you transposed it and how you solved all the problems that we mentioned in the introduction. So please, Iacopo, I think it's your turn.
Thanks for the invitation. I invite you so much because I would love to be in Madrid, but had no time to join, so it will be for next time. Honestly, I don't know if we solved all the issues that you raised, but probably we put some ground to work on collective redress in a way which is improving respect to the past situation. Can you hear me? Just okay.
We can hear you, but we can't see the presentation. Can we see it?
Okay.
Oh, okay.
It's coming. So, considering that in Italy we are making things quite complicated sometimes, at this stage we have 3 different collective redress action. 2 of these actions are based on consumer protection, and the first one is applicable for any claim which have been, regards for potential damages happening before 2019. On the other hand, we have a general class action which was introduced in 2019. If you go ahead with the slide, maybe you can we can have a preliminary slide 3, please. We can have a short summary of what are the potential action in Italy. So, as you mentioned before, apart from this limited scope collective redress dedicated to consumer, we implemented the directive in Italy in 2023 with a legislative decree, which to a certain extent reproduced main of the main topics provided in the directive. But obviously, we also introduced some specific issues which were governed in a peculiar way that we will see in a minute. So the Italian collective redress, which transposed the directive, as provided in the directive, is completely focused on consumers and potential violation regarding a violation of the Italian consumer code. I will come immediately to your point, to the point that you raised before, and we have a long list of topics which are covered by this class action. It goes from liability for defective products, unfair terms of in condition of contracts. We have e-commerce, product safety, data protection, but nothing specifically dedicated to investors' action and investor fraud. So the situation is quite the same. But as we will see afterwards, as we have some statistic about Italian implementation of collective redress, almost 50% of collective redress are focused, are addressed to banks for introduction of null and void clauses which are such to be considered in violation of the consumer rights. But this is nothing. This has nothing to see with, fraud, which are related to investors. The only instrument that we could rely on is the different action, which is the traditional class action, which was introduced in 2019, modifying our code of civil procedure. And this is open to any kind of action. It has not limitation in terms of subject who can pursue an action. So we can have consumer associations, but also the private entity and private subject having a specific interest in that claim. So the point is that we have two different types of actions, which have, to a certain extent, some similarities, but have a different scope and a different target. The question that is going around here in Italy is if it was necessary to have this number of different action, because actually this is something which can provide some potential difficulties. Imagine, for example, if you start a collective redress based on the consumer class action tool, and then on the other side there is an action brought by a single consumer or by a single entity using relying the traditional class action. We can have a kind of potential overlapping. So this is actually the main point that we have to consider when approaching the Italian market. We have two different paths which are similar to a certain extent, but with different approaches. If you go ahead with the next slide, we will touch very quickly the main features of the Italian taxation based on Article 840 of the Italian Code of Civil Procedure. As I mentioned, this action may be brought by individuals or association representing affected parties. And obviously, these associations have to be included in a specific registry, but the mandatory requirements are less strict than for the consumer redress. Obviously, here we have a principle of admissibility of the action, which is based on the homogeneity of rights. So you have to bring homogeneity rights, which obviously are evaluated by our competent courts. Then this is very interesting point that we will discuss more in depth afterwards, is the opt-in mechanism. Obviously, we have an opt-in mechanism all over Europe, but this is very interesting. We have a different opt-in window. We have an early opt-in, which is at the beginning of the action, and we have a late opt-in, which can be exercised by the consumer or by the interested party at a certain point of the procedure. And this is quite interesting because the purpose was to broaden the potential inclusion of subjects into this kind of actions, because we all know that one of the main criticalities that we are facing regards, let's say, the difficulty in bringing on board potential subject interested to join the case. Another interesting and common point is that the jurisdiction has been assigned to specialized court on enterprise matters. So we'll bring on board a more sophisticated and capacity by the judge to know these cases, because they are considered in Italy as the best in class, let's say. So this would be very, very useful to keep and to manage very complicated actions. And in the end, what you will get is a final judgment where the court ascertain, I mean, if the respondents has infringed or not infringed the rights of the claimants. Once again, we have two different and potential request. You can get an injunctive class action, so where just you were just imposed to the respondent to refrain from any further action, or then you can have a let's say a compensative action where you ask to get compensated for the suffered damages. But let's go ahead and move to the second action, which was introduced, I mean, in the transposing the European Directive on Representative Action. Once again, we have to focus on only specific topics, which are those listed in an annex to the Consumer Code, and only consumer association have the legal standing to sue the enterprise. But this is quite complicated, a very complicated point, because the way to get certified is not really easy, because you have to prove that you have a certain period of action in protecting consumer interest for at least 12 or 24 months. Then you have to bring on board many requisites that allows you to be certified, and these requisites are very strict. These mandatory requisites are very strict for national entities, and this is I mean, a point which gave rise to some let's say objection, is that foreign entities have an entry level of mandatory requisite which is lower than national entities. I mean, to be allowed to rely on this kind of action. Once again, the jurisdiction is demanded to the commercial division of the court, of the specialized court, which are based on the main region in Italy. And the scope of application, once again, is very, as I said before, limited to a very specific scope of consumer-related claims. Once again, we have the opt-in mechanism. So as I have anticipated, and you can go ahead with the next slide. One of the points to be discussed is who has the legal capacity to sue, and in the consumer action, the approved consumer association, which names are published on the Ministry of Made in Italy and Enterprise website, are the only one entitled to bring an action against enterprises. This is very important, but this is also very important to mention that these pre-approved consumer association do not need to get a specific appointment by consumer, but they can start the action without being appointed, because they are considered as having a specific interest in pursuing consumer rights. So they can start the action without getting a specific appointment. So this is very important. Then
Iacopo, I don't want to interrupt you in your presentation, but we're still looking at the wrong slide here. But maybe we can also have some questions. Now we have the right one, exactly. So maybe we could also open a little bit discussion on this. So if I summarize your presentation, Italy was one of the few EU member states who transposed the directive, and you described to us the two possible instruments, legal instruments for consumers. And I think that's the topic because it's mainly for consumers and it's not for investors, right? Did I understand that's right? Not for investors and not for shareholders.
Not, you're right. Not for investors, not for shareholders.
And again, I think that was very interesting. You described to us that you have an opt-in mechanism, not an opt-out, as in the Netherlands. And the collective redress is only open for qualified entities, actually, just as the directive tells it. So a very interesting point of view. Maybe we will stop here, but I'll come back to you, Iacopo,
Okay.
if you allow. And I would
Sure.
turn to my colleague here from Javier Cremades, and maybe you can tell us a little bit how the legal situation in Spain is. I know Spain did not transpose the directive so far, but maybe you can give us a brief overlook of how is the situation for investors in Spain. Rafael.
Hello, good afternoon. Thank you very much for this opportunity to explain the situation in our country. Well, first, regarding the collective redress directive and its implementation in Spain, well, as usually is happening in this moment of the, let's say, of the government situation in Spain that do not allow to implement many things because as you know, the Spanish government is a coalition and there is a lot of discussion between them. So it's very difficult to go ahead with really important things, no? And unfortunately, this is one of the topics that has been blocked, no, and is on standby. The government present a proposal to the parliament in March this year to implement the directive, but it was not finally included in the law. It was issued a law that has been applied starting the application the 3rd of April. This law that is called in Spanish Ley de Eficiencia Procesal, and try to, let's say, to improve the procedure in the courts, no, but it do not make any mention to the directive, no. The reason is that the members of the coalition do not agree if they do not agree the different parts of that, no. So in this moment is blocked in the parliament, and I mean, as far as we are concerned, this is not going to be issue in this period, no, in the next probably unless in the next 2 or 3 years, no. So what does it means, no? That when collective actions is issued or is done in Spain, the procedure is really very tough, no, and difficult to go ahead because each person, in our case, the shareholders, no, for example, each shareholder has to follow and present its own case, no, and each case has to be presented, has to follow the legal procedure in the court, no. It's very difficult to get to put together all the cases because only very special situations that's possible, and then that means especially in the civil cases that at the end of the day it is not easy, and then you have to act, let's say, more trying to get influence or power in front of the demands to reach an agreement, no.
Never give away the microphone. Rafael, but I think there might be new cases of collective redress coming up in Spain.
Yeah.
And I think yesterday already we mentioned the blackout in Spain as a possible case. Maybe you can tell us a little bit more about your approach and how could this develop into a collective redress case?
Yeah. Okay, before entering the blackout case, I just would like to mention that, in Spain, there has been the most important collective case probably in the last years, because it was the Bankia case. This case affected 800,000 shareholders, minority minor shareholders, and it was really crazy situation, And finally, the government of the Popular Party decided to clean and sort out the situation by turning back the money to the shareholders, But it was because case by case there was different decisions in the courts, But it was a massive case, 800,000 of minority shareholders really lost the money in this public offer, when this bank was which was the Bankia was the result of a merge of different saving houses, in Spain. But this year, I think that we have had there are two cases that have had affected the interest of the minority shareholders. One was the Talgo case. You remember that was this Spanish company, player in the transportation industry. They makes trains and so on. And there was a public bid from a Hungarian company and the operation was blocked by the government, And really the damage for the minority shareholders has been huge because of course the quotation or the price of the shares of Talgo has never reached by far the price that this Hungarian company really offered. So what happens in this case is that a lot of money lost. Almost this case was can say that the economical damage will be something like 600 million euros. What happened? Nothing. So minority shareholders lost the money because the government decided that it was good for them not be allowed to sell. So and this is probably with this directive point, the situation will be different. But let's remember that in Spain, still the government has the possibility to block any takeover or any investment in any company. This is a regulation that was issued during the COVID, to protect the Spanish industry. But still, though the COVID is gone,
it's still in place.
It's still in place, yeah. But just not very important, But the law is still in place, and the government has not any they have not any problem to apply according to their interest, And now it is another case interesting that just to put in the table, it's ongoing now, which is the bid, from Banco Bilbao Vizcaya to Banco Sabadell, The number of minority shareholders in the Banco de Sabadell is 100,000 people, who of course institutional and financial investors are not included here, but the number of, let's say, citizens that invested the money in this bank, which is, by the way, a very competitive bank, is a very relevant number, So the situation now is that the Banco Bilbao Vizcaya present this bid. the Spanish competition regulator, the watchdog, the Comisión Nacional de Mercado de la Competencia, has approved, has said, okay, it's no problem for markets and competition law. And now the decision is in the hands of the government, and they have to decide before the 27th of June. But the problem here is that the offer, financially speaking, is good for the minority shareholders. It's good, no? But the concerns, I mean, that means that the Banco Bilbao Vizcaya has made a good job in terms of, let's say, analysis, economic analysis, and so on. Say, okay, the value is this, it's a good offer, no? But the government has, I think they have the temptation to stop the operation because there are political issues, especially from the Catalonian parties, no, you know, the independent parties. They don't want to lose any financial institution that was born or had any relation with Catalonia. So it's very interesting. I'm sure that any other government, not in the situation in this weak situation that this coalition has, will have any problem, of course, to approve this operation because it's good for the shareholders and especially for the minority shareholders.
So interesting cases from the investor's point of view, but not exactly collective redress cases, or at least not the potential for it, but maybe the blackout case.
Okay. And then what's happening with the blackout? No, well, the blackout, you probably know in Spain, we have the energy system fall down the 28th of April. No, it's the technical explanation is not known. You can, if you ask your friends, everybody has an explanation, especially if they are engineers or have some kind of knowledge, you know. But the real life is that almost 66% of the energy, the production, stopped in 20 seconds. So the country was out system, no? Everything, computers, light, everything that we need to live was stopped, no? So in Spain there is one entity that is let's say is really controlled by the government, although the participation is 20%. The government, but for different reasons, it's a strategic company, no? Is controls and manage this company, and this company is the responsible to guarantee that the energy is going to be always available. It's always doing connection, no? Of course, this company is quoted, no, in the stock exchange. The minority interest is around 11% of the total equity, the shareholders' equity that is in the market. 11% is in the hands of minority shareholders, no? There is an important part in the hands of institutional investors, no? That, you know, indirectly affect as well to minority shareholders, but in this case it's 11% of people, no? I mean, we had a chart. I don't know if my friends can move the slides.
Maybe the next slide.
The next slide.
Okay.
Well, later we can.
Yeah, no problem. But so there are the minority shareholders of Redea or REE.
Yeah.
They suffer.
Yeah,
you know, from the share price and
exactly. They suffer because this is the chart, no? We can see this. This is the 1 year, no? And sorry. Yeah, and we can see this is it was the day. It was the day when the blackout happens, no, and then the price fall down, no, dramatically. So the economical damage was important, but I will say that it was not only the problem itself, no. The question is if this could happen again, no, in the future, and again could damage the interest of the minority shareholders, no. And well, we can go further and to analyze what can be done, no, in these cases, no, and but to try to, let's say, to make any kind of action on this topic, no.
Great. That's a good idea. So maybe we'll come back to this a little bit later. Mark, sorry for you that you always have to stand up so we can see the presentation. Mark, you're chairman of the World Federation of Investors. Everybody knows it, but you are also, of course, an expert of the UK legal system, I would assume. And as we know, the United Kingdom, they have something which is called group litigation orders for claims with common issues of fact or law. And we would like to know a little bit more about your experience with this instrument. What did you hear? Does it work? Does it not work? What are the pros and cons from the investor's point of view? Maybe you can give us an insight in the UK situation.
Sure, by all means. I'm different from my fellow panelists in that I have no legal background. So I am talking from the perspective of the investor. User is the word that we've had, we've been banning around for the last couple of days, but also the behaviour of the shareholder organisation, both in the UK and around the world outside Europe. And as the questions go forward, I'll probably do a bit of hot seating with David, because if we get into legal territory, particularly on the US, I think you've got a deep bench of knowledge here that you should.
We will ask for his expertise.
Super. So UK, yes. I mean, GLO is actually it's just it's a mechanism that can be used. It's not necessary for it to be used in a litigation. It is a mechanism for taking multiple claims through multiple claims managers and lawyers and tying those together. So it tends to be the case that if something is identified as a harm to investors, that 4 or 5 claims will pop out of the woodwork. And they tend to have different terms associated with them, and they build books of investors who would like to follow those claims. And at a certain point of time, they end up in court, and the court decides, is this going to be effectively case managed by the court and run as a single case, or are they going to be left as individual? And so a GLO is a mechanism for tying those together. There are various routes by which collective claims can be handled, and there's nothing wrong with, again, to my understanding, with a law firm and funder taking forward multiple claims that are the same under a single action. There is a concept of representative action similar to what was being discussed by Iacopo, but that is fairly rarely used, and it has specific circumstances attached to it. And there is also a concept of a collective procedures order, CPO, and that is used for competition cases. And in the UK, there are a couple of routes which are favoured by litigation funders and by law firms for collective redress. And one is competition, for the simple fact that there are better developed procedures around it, but also it involves an opt-out. An opt-out is favoured for the reasons we've been talking about. The other route that tends to be used is FISMA 90 and 90A, which are effectively prospectus and information breaches, because there's a lot of things that a company can do wrong, which don't easily create a right of action for an investor. But if a company puts out information which is incorrect, particularly in a prospectus, it's a very simple statutory route to get to them. So we have a redress system which has effectively been built on legally since around 1990. It has moved left and right. We started with a concept of contingent fee agreements, which were then effectively barred and then effectively brought back in. We've moved to damages-based agreements, which allowed a percentage of the damages to be paid to lawyers and more recently to funders and to cover ATE as well. That has all been thrown up in the air by a recent case. So there is Merrick versus MasterCard, which has just been decided, which has effectively challenged a lot of the existing documentation, which is covering cases that are ongoing, and has effectively made a lot of those agreements unenforceable. That has a negative effect on the market, because funders are realizing that the law is changing. It's changing not necessarily in favor of the funders, and it is putting them at risks that they did not initially anticipate. The other element that is concerning funders at the moment in the UK is regulatory action. And the regulator, neither the legal processes nor the regulators are very friendly to funded litigation in the UK. And the regulator has developed a habit of waiting until very late in the process and intervening and effectively overriding the private cases that are running through the courts. And the effect of that is that there is a total loss of funding by the funders. There's a benefit to the investor or to the end claimant, because it ends up being an opt-out, or not even opt-out. It ends up being an automatic payment to the claimant. So there's a benefit from their perspective. But it is the reason why the regulator gets involved in many cases is because it is forced to do so by the existence of private claims, which create an expectation. If it can frighten off the funders by effectively overriding them at late stage, so that no cases become unfundable in the UK, then it no longer gets embarrassed and it no longer intervenes. So we have a very nasty, vicious circle in the UK. So I'm not going to present UK litigation finance as a shining example.
No, I did expect that, but I have to admit, even though you're not a lawyer, that was excellent. Very good. So I think, talking about funded litigation, I have to take a look to David, because we have the possibility to ask him to say something about the situation in the UK, in the US. And I don't want you to explain now the whole class action system, but maybe we can cover, for example, the funding and the contingency fees. What are the lessons we can learn in Europe out of the US system without copying the US system? David, please.
Can you hear me? Yeah. Without copying is a big caveat. I'm not sure I'm going to go on a limb and say it, and I know this is not practical, but I'm saying it should be copied. And there are really three components that make class actions for investors a success. The opt-out procedure, which we all know about, but that's really important because it gives a sense of the size, and and even beyond that, when you're evaluating the risks of a case, if you're a lawyer like me, you understand how big it is, and it already starts at the largest. You don't have to bring people in, and you don't have risk of it decreasing in size, or at least not serious risk, with some exceptions. So that's really important. But as important is the contingency fee part of it, because you're not, because you lose some of these cases. These cases are hard to bring. Even the ones that have good liability, sometimes you'll have trouble. Say if the market, when Trump had Liberation Day, the market plunged. Well, maybe there was securities fraud the day before, but you can't distinguish the stock price drop from Liberation Day versus whether it was from the fraud, and so you don't have a good case necessarily. So having contingency fee allows you to take cases even if they're risky, because then on the ones that you are successful, you're able to make back the money. And then I know this isn't practical, but the no loser pays. There's no loser pay rule, and that's really important for a couple of reasons. One is it lowers the cost for bringing a case. It lowers the cost significantly, and then in addition to that, you don't have to deal with funders, and funders are difficult. Most importantly, because they're expensive, but also they can make it difficult to manage a case because you have to justify everything at the outset, and you can't be flexible during the litigation. So not having a funder involved, when you do have a funder involved, you often have to, it sets the bar higher for where you need to settle to make any money. So those three components are really, really helpful in the United States. I know they're not necessarily practical here. But that's, and in terms of funding, the way it works in the United States for the most part, I mean, you can get funding for securities cases, but usually the law firms themselves do contingency fee work, act as the funders. They create their own litigation funds. They finance the case through the duration. And, so we act as venture capital funds to some degree.
Thank you very much. So there's a lot we can learn from the US. And do you want to add something, please, Flip?
Well, I think that in the Netherlands, we have the problem with the defendants boiling up all those detailed problems. And I would be happy if the defendant, if it's a frivolous defendants, that they would have to bear the real costs. So those are really paid, please.
So Iacopo,
but only in case of frivolous defending.
Iacopo, we did not forget you, but maybe you can give us a short view on, what is the situation in Italy on contingency fees, funding, and stuff like this? Maybe you can say a bit about the situation in Italy, please.
Yes, sure. Well, let's start with a preliminary rule. The contingency fee agreements in Italy are void and null. So you cannot agree on a contingency fee agreement. However, the law provided for, in respect to lawyers, provided a certain way to mitigate this very strict rule, because what you are allowed as a lawyer is to get a liquidation of your compensation based on the number of people affected by the action. And so this is one of the first point that you can work on. So if you go to Article 8049, it provides, for example, that if you are in a range between 1 and 500 people, you can get a compensation not exceeding 9% of the value of the claim, and so forth, up to 1 million for 0.5%. So you have this kind of this liquidation, and this liquidation is considered as a success fee, which can be liquidated by the judge, but the judge has the power to cut off up to 50% of this amount. So what happens in practice, that you get paid as a lawyer for your usual fee as provided by professional tariffs, and on top of that you can get the liquidation of a success fee, which is liquidated based on the criteria that I mentioned before. But you have the risk to suffer a potential cut of your fee up to 50%, which is not the same, because in Italy probably we didn't enter into the detail, because after ascertaining the violation, Then there is a third phase where after the admissibility phase and after the merit phase, you have a liquidation phase, and in the liquidation phase, it is appointed a judge, and there is let's say a subject who overlook the liquidation of the due amounts. I'm referring to the consumer action, and this guy can get from the judge an increase of his fees up to 50%. So lawyers are less lucky because they can just get a reduction of 50% of their fee and not to get increase from the judge. So the real point is that actually from a legal field perspective, the situation is not very let's say encouraging, even if it's not that bad as it was before. So the principle is no contingency fee, but you can get a success fee based on certain criteria. Obviously, we have another point to consider, that obviously we have the loser pay principle, and this is true in respect of traditional class action, which is the one on which, in my perspective, investors can rely on, even if we don't have a real strong case law in Italy on this perspective. But the real positive implementation of the directive in Italy is that consumers have not to pay the legal fee apart the case of litigation started in bad faith. So the consumer has not any risk in payment of the legal fees in case of unsuccessful case, unless for the case of bad faith.
Thank you, Iacopo. That was very interesting to find out. But what about Spain? Do you have something like contingency fee, and what about the costs for investors?
Yeah, okay. Well, Spain is different, as usually happens in life, no? And in this case, we have before 2008, the fees, the legal fees for the lawyers, were really were issued by the bars, no? So it was a kind of regime where the prices was under control. But there was a decision from the High Court in this year, in 2008, and it was declared that the contingency fees, what we call in Spain quotalities, these are success fees in any kind, was completely legal, and there is no legal, and there is any kind of restriction. So you can make 50% contingency fees, 90%, whatever, both parties agree, no? So in this way, normally, we have to say that depends of the kind of action, no? But this kind of damages, no? Indemnities could normally is around 20%, 25%, but could rise easily to 40%. There are some directives in the European Union. Over 40%, 40% is not allowed and could be discussed in the High Court of the European Union. No? So contrary, we have this problem of the process, no? That we have a very difficult process. So what happened? The companies who are in this market of finance cases, no, are very interested because there are no limits in Spain. But on the other side, the case has to be very clear, especially from the legal procedure point of view, because otherwise there is a lot of difficulties that makes that the risk goes very up. No. The funny thing is that it's more easy to let's say to build up a kind of class action in the criminal in a criminal case. So you can put together 10,000 people in one case, the criminal court. The criminal court can set an indemnity too. So this is why it's very usual in Spain to the first action to go for a criminal in the criminal court.
Thank you very much. So I think it's paradise for the attorneys here in Spain. It seems to be a good solution. But let me open the discussion also to the audience. I mean, we heard so many experiences now from the US, the UK, Spain, the Dutch model, and Italy. What are the things that concern you? I mean, one of the major issues, I think, is still the funding, but maybe you are interested in even other points. Yes, Matis, please. Does it work?
Oh, okay. Now it works. So I have a question for all panelists. We have gone through some of the difficulties with the class act or collective redress system, or lack of system mostly, as there is now. But and we know it will be still at least a few years before the collective redress directive is reviewed. But if I could ask each of you to say, and we will collect this kind of info also actually in a systematic way, but one thing in either in your country or in general at the EU level, what would be the one biggest thing that you think could improve the system? If it was an open letter, Chris, to Santa or the policymakers, what would be the one thing?
Excellent question. Mark, you want to start, please?
Yeah, two things, not one. One we've mentioned many times is opt out. I think that is fundamental. In many cases in Europe, the rationale for certainly shareholder organizations supporting an action is fairness. And that fairness comes from the fact that, as with Stellantis, for example, US investors have been paid out. And suddenly you have you've broken the sort of circularity of shareholders suing their own assets, because you have one set of shareholders which has been effectively paid out, and another set that doesn't. You have an uneven playing field. If your logic, and it's not the court's logic, it's the shareholder association's logic, is that fairness is the driver for supporting a case, then logically you have to ensure that everybody who's affected gets fair redress, and the opt out ensures that anybody who's affected will get paid unless they do something, so that it has that fairness. There's a second layer to that, which is at the moment the opt-outs where they exist tend to be national. And I think they need to move to being international, at least Europe-wide, so that you can take that concept on without multiple actions. But that sort of leads me on to the second element. We mentioned frivolous on the way through, and it's a concern with the US approach. It's a reason why funding can be useful. Part of the due diligence process that an investor has to do, and very, very often investor associations and the likes of Better Finance and World Federation of Investors end up looking at a case and saying, well, I do due diligence from the perspective of the end investor involved, and actually funding tends to be a useful due diligence process, because it's the legal questions have been gone over with a fine-tooth comb. An assessment has been made of the validity of the case. But what concerns us, I think, is also that's still from the perspective of, can I win? And there's more than can I win that goes on here. Can I win? But is it in the best interests of the investor, of the putative claimant here? for this case to go ahead. And that's a much more complex question, and it's something that we spend an awful lot of time looking at and getting ourselves over the hill for a variety of different reasons. Our preferred situation is where there is third-party pockets. So an example is where a fund manager has misbehaved and the fund has been hurt, and there's a route through the fund manager. There's a case in the UK, which is Woodford Equity Income Fund, where there was mismanagement of the liquidity position. There wasn't a lot of money to go after at the manager, but there was this concept of an authorized corporate director, which was Link Financial Services Limited, subsidiary of a large Australian company, which was a deep pocket and which was, from a regulatory perspective, on the hook. So the investors find themselves suing not their own assets, but suing third-party assets, and so we look for that, but that's not always possible. So I know I need to go there. But my point is, how do we build? And I'm interested to hear from Flip the role of the independent board. How do we build a filter that ensures that an action is in the interest not of all parties, but of the effective claimant?
By being an independent board. Now, thank you for those points. It gives me the opportunity not to name those two, because I would say the same, but indeed the third point, and that is, I would like to have the requirements easier, and that should be possible having an independent board, because we are really independent. So we have nothing, we have no financial interest. We have more or less a low remuneration. It's not a commercial tariff, definitely not. So we have nothing else but to think about the interest of the investor, and then you do that. It's very simple. So I would say that if we can prove, if we convince the court that we are an independent board, I would say that is all the requirement that is necessary. No book building. It's all fuss that can come later. Then we can get into the case. So that would be on my wish list.
Well, maybe we should turn to David,
only one
because
point.
yeah, go ahead. You want to?
That's what's fine.
Okay, great. David, I think we should use your expertise, because I mean, in Europe, as you know, we don't dare to use the word European class action because we don't want to use any US things. So we talk about collective redress, right? Because it sounds a little bit nicer. And nobody in Europe really wants to have the US system, because everybody says, they're aggressive attorneys and it's expensive and it's awful.
I would deny that.
Yeah.
Let's get a bit more American.
Yeah, thank you very much, because that's exactly what I think. Maybe we should.
Hello. Yeah.
Whatever. Maybe you could tell us a little bit. I mean, it sounds so easy in the US, you just find a funder, but there are a lot of mechanisms, and maybe you could say a little bit more on this. I mean, it has also to do about somebody has to assess the success of the case. And if you don't have a high proportion of success rate, you will not find a funder. So you already have kind of a mechanism and a filter. I don't want to fight for the US system, but I think there are a lot of lessons we can learn from the US, which would be useful for our system in Europe. So maybe, David, you could share your experience.
Yeah, well, I think that there's some really good points that are being made about other ways of doing this. So I don't want to, especially, I don't want to say that the American system is the only way to go and the best way, but it is successful. And the reason why it's successful is because there is a low barrier to entry to filing cases. The downside of that is you may have some cases that aren't good that go forward. But I can tell you, some of my best cases weren't the cases I thought were the best when I started them, and some of my worst cases were the cases I thought were the best. And sometimes it's very hard to know which ones are going to be successful, and sometimes the outcome is determined by things well outside of your control, at least in the U.S. system, which is not particularly predictable. And the one thing that has happened in the U.S., because the barriers to entry to filing a case are very low, is that the courts have really set up very high barriers to succeeding. So you have to have a very good case to get through what's called a motion to dismiss. So there are other ways in which there's a filtering process in the US. Now, it sounds like that's what's they're attempting to do, the defense bar, at least in the Netherlands, right? But I do think that having a low barrier to entry allows cases to come forward, and you know, and there are some downsides to it. I'm not going to say there aren't, and some plaintiffs' lawyers in the U.S. are aggressive. I'm not one of them. I avoid confrontation. Some are very rich, but that's also an incentive. But that's an incentive for people to do these cases, right? To go forward. The other system in place in the U.S., which may not be music to the ears of those who support retail shareholders, but is this system where the institutional investors or the largest losers in a particular litigation are the ones that lead the case and appoint their own counsel. And the idea is they'll be responsible, and they won't be a pushover for the lawyers. They'll tell the lawyers what to do, as opposed to lawyers telling the retail shareholder what's in their interest. So there is that idea, this concept of having an outside, you know, fiduciary for the class, who's not the lawyer, who also has a fiduciary duty, by the way, but is leading the class as a class representative, this lead plaintiff, it's called.
Thanks.
Sure.
Thanks a lot. Maybe Rafael, you give us what would be, coming back to Martin's question, actually, what would be the next step that we have to go?
Okay, well, I think in the case of Spain, of course, the most desirable scenario was that this collective redress directive was implemented, no? But I'm quite, let's say, reasonably skeptical about that, no? Because the problem of the, let's say, collective actions in Spain is that the courts and the judges has in their DNA, no, the idea of that to be compensated with high amounts, no. Let's say it's not very clear, no. So you have to everything that makes easier, no, this kind of with these mechanisms of best procedures and so on, and it will end in a lot of processes, a lot of cases, which doesn't like very much to them, no. So what is really important from my view, from my point of view, for the shareholders in the Spanish, especially in the quoted companies in Spain? Something that you said, no, that the board has to be responsible, and in Spain, the best way to make the board, the persons in the board, responsible, is to let them understand that they could be harmed by the criminal code, by the criminal law, because maybe they personally are not going to be affected very much, economically speaking, but the reputation is going to be lost, and they are going to suffer long processes. They are going to be really have a big damage in their public image and so on. So I will reinforce very much the criminal regulation, the criminal law regarding the performance of the members of the board.
Yeah. Iacopo, what about Italy? I mean, you're always behind my back, but I don't forget you.
I oversee you. I oversee you all.
Step which is necessary to go forward.
This is $1 million question, actually. But once again, I'm going back.
Speak a little bit louder, please.
Can you hear me? Can you hear me? Can you hear me now?
Good.
Okay. This is $1 million question. And going to the $1 million point is very important, going back to what was said before by Rafael. The point is that in Europe, we have a system where damage compensation is always set at low threshold, because we don't have punitive damages in Europe, or at least in Italy, as it happens in the United States. So this is a very big difference, once again, that we have to consider, because the damages that can be liquidated are much more lighter than in the United States. So I don't want to say that punitive damages has to be introduced, but obviously I agree with the panelists about the fact that the opt-out is an option, but actually this is not in our culture. So this is a dream at this stage, and probably what we try to introduce here in Italy with a later opt-in after a decision on the merits, which allows the consumer, or I mean the interested party, the shareholders, to join the compensation coming out from the first phase decision on the merits, can be, I mean, a compromise, because you can have a middle way where you can get the option to be on board from a point where the court has assessed the violation by the respondent. So another point is to regulate how third-party founders can be involved in the process. At this stage in Italy, we have considered these third-party founders as an option available, but we are still in a gray area, because obviously what concern the Italian legislator is to avoid potential conflict of interest, but the conflict of interest intended as a competitor of the enterprise, of the respondent, or any subject having an interest, conflicting interest. But if you have an independent approach and you don't have any conflicting interest, third-party funding is allowed. But once again, there is not certainty about the potential return that you can have from funding this litigation. So we should also clarify what's the role of funding parties and how they can gain, legitimately something out of this action, because they are investing and they need to get, a return from their investment. And this has to be clarified. And then last but not least, my suggestion would be that of easing the procedure, because the procedure are too long, it takes too much time, because we have a proceeding here in Italy starting in 2021, 22, and they are still pending, and we cannot see the end in a reasonable time frame. So also the length of the procedure is an issue.
Thank you, Iacopo. I think, Mark, you wanted to add something?
Yeah, I got two short points. Just the first one on opt-out. It's very difficult to communicate with all of the potential claimants in a claim. Usually, there is one person, which is the company or the fund, who sits on a register with the capacity to communicate directly with those people. If you don't have an opt-out, and if the judges, and they resist valiantly, don't instruct the company or the fund to communicate the fact that then the majority of claimants never, even if it's in the newspapers, even if it's advertised everywhere, never find out. Also, the costs of that advertising are huge. But another layer of it certainly is culture. So maybe surprisingly, but in the UK, there is not a culture of claiming. There is a culture of blaming oneself and believing in a caveat emptor approach. I bought this share, I bought this fund, it's gone down, I made a mistake, I don't have any right to claim, even though the law says that you do, even though and so persuading people to claim is an awful lot harder than it should be. That's point one. Point two is very brief. Coming back to Rafael's comment on criminal procedures for board directors, I just caution that has a secondary effect of reducing the pool of high quality directors, and that is a very real. There are people in this room who know this very much. That has a real effect of devaluing the quality of boards. So you need to be careful of how much you use that mechanism.
Thank you. Very interesting. Let me turn to David again, and I think we can still learn a lot from the US system. But if you look at Europe, and you are in the middle of Europe here in Madrid, what would you recommend to us? What would be the next steps that you should take? I mean, we understood we should lower the barriers, but what else is very necessary to not to copy the US system, but to have a better system for the investors?
Yeah, you should definitely not
And
follow.
may I add a question to that?
Sure.
What would be the trigger to stimulate out-of-court settlements?
So I'm at a loss a little bit. I agree you should never call it a class action if that has a stigma here in Europe, and you should call it European, not American style. And then, but I do think there are certain things lowering the barrier. You know, in the U.S., the law empowers the judges to give fees. So there's some control there. I think a lot of this is changing the mentality in Europe to allow lawyers to be able to take more risk and get more reward, and then making sure that there's a check on them. But doing that would go a long way. And if you're allowed to sue, and we've already talked about opt-in to the so we don't need to talk about it anymore. I would say though that these cases are I mean, I've looked at cases in the UK. I'm involved in a couple of them. They're very hard, and they're very hard to do, and especially with the funders, it just makes them very impractical. And so I think somehow lowering the cost of funding, however that can be done, it would be useful.
And if you look at the Dutch model, I mean, I know it's a settlement model, and that's what you are emphasizing. But couldn't this be an attractive alternative to solve our problems in the EU?
I think the Dutch model is a great model. I mean, it sounds like it's hitting some road bumps just in terms of the procedural motions from the defendants, but no, it sounds like a very good model, and it does have a lot of the controls that maybe at least on the face of it differentiate it from the U.S. model.
But because at the end you have a settlement, and that's probably the main difference to all the other systems. But Flip, maybe you can say from your perspective, I mean, we see the Dutch model a little bit as a blueprint for the EU, but maybe you see also some disadvantages of the Dutch system. What could we do better on the European level?
No, I don't see disadvantages, but it's not grown up yet. And the main goal is indeed out-of-court settlement. And the big point, of course, is if there's no settlement, then the judge can decide, and then the case is ended. So that's also okay. So there is a stimulus for out-of-court settlements, but until we have these Supreme Court cases on the requirements phase, it's difficult to reach those settlements. Therefore, I was interested if there is any way in the states that you.
So in the States, I'm sorry I didn't respond to that first. Practically, as I said, it's a very high bar to get through what's called a motion to dismiss, right? The initial pleading has to be very, very strong to be able to survive. So once you're through there, it adds a lot of risk to the defendants. And then once you get a class certified, so the class isn't automatically there. There's certain burdens that plaintiffs have to show that there's homogeneity, as the Italians say it, homogeneity of we call it commonality or predominance in the case. Once that happens, then you have your sort of a known quantity of damages, and the risk is a lot higher for the defendants, a lot lower for plaintiffs, and generally settlement occurs around that time. It can go to trial if the liability is weak, right? You can still end up in trial or losing, right? But once you get through the motion to dismiss, you usually have a good case.
On the other hand, Flip, if I think of cases like Volkswagen in Germany, I mean, if the companies do not want to settle, what do you do? So, and that is the charm and the sympathy. That's why I have a lot of sympathy for the US system. Because if the companies just refuse to settle, because they think they have a better position,
but
then it is really hard to defend any investor interest.
that's in the new system. It's possible. Then you go to the last phase, and that's go to court and do all the legal steps necessary to get an indemnification.
So we have to keep an eye on the Netherlands.
Oh, definitely.
Definitely.
May I say
Yes,
just
Iacopo.
one thing? Probably just to reply to, an incentive for settlement is that companies are not really scared because because of the length of the proceeding, as you said, Jella, if you cannot get their availability to settle, is a strategy for them because they can bring the case along for years. The risk is very low for them, so they bet on a decision that probably will never come or will come in years and will cover a limited portion of affected persons. So for them is more convenient waiting than going to court, unless the court decision become very strict, very short, and they represent a risk. And at this stage, then you can get people more interested in settling than going into court.
Thank you. I think, Guillaume, there's another question. Mathis, did we answer your question? Great. Thank you very much. Guillaume, please.
So, great panel. Thank you very much. I just wanted to add a piece of information and to have your reaction. In fact, it's to add one point to Matthij's question. Late last year, I received a questionnaire from the Commission on funders of collective redress class action. It looked like really an investigation against these funders, which are still rare in continental Europe and all come from usually the UK or Canada or the US. So Mark told us they are already struggling, but obviously the Commission doesn't like them. So it's not only that we have a very disappointing collective redress directive, as you said, Jella, is minimum harmonization, poorly transposed, a lot of restrictions, no opt-out, excluding specifically in the annex direct investors into shares and bonds, as you said. But in addition, they are targeting, for me, quite obviously, funders because they see a few cases, modest cases, sorry, no offense, of the Fiat Chrysler in Europe. And despite all evidence that even in the Netherlands now it's slowing down because of the reasons Flip mentioned, we have many examples. We could have Volkswagen diesel, they have been paid in the US, we have not in Europe. I spoke about yesterday at the general meeting, Adolf, now the liquidator has paid billions to US investors, Lux Alpha Fund in Luxembourg, zero, etc., etc., and Wirecard, etc. So I think my additional question for the Commission is how do you reconcile saying that the Savings and Investments Union is a top priority, which means to give a possibility of higher returns to retail investors by moving into capital markets, where you need trust, it's one prerequisite, and on the other hand, still shooting at any possibility, practical, effective possibility of getting collective redress for individual investors. This would be a point I would add, and I would mention this survey/investigation against funders.
So who dares to answer, Mark?
So for absolute clarity, there is nothing wrong with the concept of funders. There is nothing wrong with the concept of collective redress using third-party funding, using ATE insurance. There are a series of protections that need to be in place, which the Commission needs to think about in order that that system is safe. One that we haven't spoken about that is worth bringing in the last few years, every funding arrangement that I have seen has been pro rata, fully pro rata, so that if 1 cent of recovery is achieved, X% will go to the investor. Historically, that wasn't the case. Historically, there was a coverage of initial costs and a waterfall. And that creates very perverse incentives and outcomes. The classic example is the Royal Bank of Scotland rights issue, which was many years ago, back 2008, 2010, I think, where there was a settlement. And settlement is another big issue that we haven't really discussed. But when you join a claim, you are handing away all control of the claim, including settlement. So somebody's going to settle, and you are going to accept that settlement. If that settlement covers first the costs of the lawyer and the costs of the funding, then there's a very good chance that the settlement will be set very cynically at exactly the level which produces zero for the claimant and covers and a profit for the involved parties. So pro rata is the pro rata is the only way forward. But the filters that we spoke about, ensuring that this is in the interest of the end investor. But I think it's a very dangerous thing for the Commission, and I mentioned in the UK the regulators effectively putting hurdles in the way of what I think are very valid redress. Redress covers a huge spectrum from fully cynical to extremely high value, and we just need to ensure that the cases that move forward are in that high value component.
Thank you, Mark. It's a little bit like at the general meeting in Germany. Then you have a red light when you have to finish your contribution. So thank you very much for the sign that we have the next speaker probably waiting. But Guillaume, is your question answered, or do you want you want to answer somehow? Iacopo, you want to? No? Okay, so let me say thank you very much to this high-level panel, and also thank you very much to David, who was not on the program, but it was really fantastic that you participated. Thank you very much. I enjoyed it very much, and it's a very, how do you say, specialist for your contributions.